Well, good evening, everyone. Welcome to this beautiful spring evening in the Boy Scout building room. Thanks all for coming. Don, there's no chairs left. Okay. So my name is Don Brown, and I'll be your moderator tonight, along with our speaker, Mr. Lee Shlamowitz, Esquire, per excellence. So this meeting actually started more than a year ago. I was sitting at the Dublin Diner, a couple of chairs away from Bill Yellen and Kenny Such, who were having a discussion about how much a contractor should charge as a deposit. And if you all know Bill and you know Kenny, they are meek, mild-mannered people. That was a joke. And they couldn't agree on that answer, on the answer to that question. So they discussed it back and forth a while, and it occurred to me, if these really experienced guys can't come to an agreement on this, I bet you that's probably true for a lot of folks. So being the kind of crazy person I am, I thought maybe we should put a blue ribbon committee together to try to get those questions answered. So I reached out to Lee as our esteemed attorney, asking if he'd be willing to be the attorney scribe and negotiator, and he agreed to do that. And I invited a bunch of other really experienced people to have, I guess, twice monthly or monthly conference calls. And we spent, I don't know, 40, 50 hours, I guess, altogether, negotiating all the points of a Rehabber-Contractor contract. And tonight is the coming out party of that work. Lee has worked very hard documenting everything. We've had conference calls with Kenny and Bill and Larry and George and Matt Heller. Is Matt here? Oh, hello, Matt. Oh, I've never met you, actually. Thanks for coming. And so tonight is the culmination of that. So Lee is going to present the work that we've all done, and you are all welcome to download a free copy of it. You should have been given a little slip of paper. If you didn't, Rich will give it to you if you don't have one. And just there's a URL or a QR code. You can use either one. It'll take you to a form that'll let you request the document. It's free, so you can download it. And so that's what tonight's about. I hope you enjoy it. Please ask all the questions that you can ask or think about. And Lee will do his best, and we will turn to our other blue ribbon panelists to answer any additional questions. So I am very proud to introduce Lee Shlamowitz, our attorney of record tonight, who worked with us, and he's still talking to us for the last year or so, putting together this construction agreement. He has a lot of experience with this, and I think he managed to keep us all. Fortunately, we were on the telephone. We weren't face-to-face, so we didn't have any chance to harm each other. But he did a really great job of corralling all of our points of view and putting this document together. And as I promised you, if you didn't get that, if you got that slip of paper in the back, you can download a copy of this document to your computer or phone for free. So Lee, I'm proud to have you.
I appreciate everybody's attention. Oh, there it is. Tonight's presentation is not the Lee Shlamowitz Esquire par excellence show. That's not what this is. I don't know how this happened. I'm the mouthpiece. This is the culmination of, as Don, I think, kind of summarized, a ton of hard work by a lot of really smart people. This is not an attorney dropping a document for everybody to read, and I'm going to do my very best to reflect what I think is a really diverse group. I think it's purposely diverse to represent these different perspectives. To give you a flavor of what went into creating this document, the document's really kind of the boring part. There's probably 40 hours of us all yelling at each other and getting in fights about minutia, but that matters, and I did my best as I drafted this document to reflect that. And what tonight's presentation is going to be about is talking to you about, these are provisions that we talked about, these are things that happen in real life, and these are the conversations we had to reach this point and crystallize on this provision for the agreement. I'm hoping that it will inform lenders, flippers, contractors. Do we have any contractors in the audience? I'm sorry in advance, my contractors in the audience. But that's the idea, is that we're bringing a group of diverse perspectives to find the common ground, and that's what this document is about. Is it perfect? Some might say it is. No, it's a good faith effort, and I think the best outcome we could have, and we've discussed, is if this gets the conversation going and triggers people's minds about issues that otherwise they would not have thought of, I think we've been successful. So I don't want everybody to clap 3 times twice, although I thought that was kind of a joke on me. I didn't know. But I do think we should give a round of applause for the contributors that all made this possible. It ain't just me. Can you guys raise your hands so everyone knows who we're clapping for? Sorry. And Don read all your names. Their bios are all available online. Very impressive people. And personally, I thank each and every one of you because I learned a great deal from each and every one of you. The second point I wanted to talk about tonight is something you'll almost never hear a lawyer say, and you'll almost never hear a lawyer say it with very bright lights and cameras in his face, which is that the contract I'm about to talk about can very easily be rendered kind of useless. We'll talk about different ways that can happen, but one of the ways that's really important is by the way that the parties and the people underlying and using this contract interact with each other. If you look at, I understand there were coupons handed out tonight. The title of this program is Rehabber-Contractor Relationship. I'm sorry, Creating a Successful Rehabber-Contractor Relationship. The key word that we return to over and over again on our calls is relationship. And you're going to see that throughout the provisions in this contract. I would say to my flippers, to my experienced flippers, to my new flippers, to people who are going to be involved in any way with the contractor deal, the critical, crucial key is not found in this contract. It's know your contractor before you bring this contract to the table. Learn about them, vet them. We had, hours-long conversations about different ways to do that, different channels you can check. Because once you've found a good contractor, you can start a great relationship with them. When you find a bad contractor, things can go really bad really, really easily. So our contract does as good of a job as we can to prevent that from happening, but a lot of this is on the flipper, and the contract can only do so much. So I will probably beat that point into the ground. Now, I was asked to discuss... Oh man, I had these here the whole time. All right, you'll have to pardon me. This is my first one I've done with the visual aid. So these are all the people we were clapping for. Phil Yellen, Don Brown, Jeff Beach, George Fagundes, Kenny Such, Larry Steinhaus, me, Matt Heller, and there we go. And they all listened to 40 hours of me talking just like this and then decided one more is what's in order. Don talked a little bit about how this project started. It was back in September of 18. I checked today that I received the first email. So this has been a labor and love for a while now. We've got our team. And this is the frame where I want to pause for a minute before we get into the legal provisions and talk about some of the things that I have seen happen. I don't take for granted the fact that I'm the attorney with the pocket square and I'm not there swinging the hammer. I do, however, have a unique perspective on how some of these deals unfold. And in that perspective and in that role, I've gotten to see some terrible, terrible outcomes from the flipper's perspective and even from the contractor's perspective. So I'm going to talk hopefully very briefly about 3 of them. And I think we can use them as kind of a canvas to illustrate some of the points that are in the agreement. So the first is one of probably the most quintessential shortcomings I've seen of a novel real estate investor, and it relates back to the genesis of this whole project, which is what's the deposit that should be put down to start one of these projects? So we'll call this the case of the huge deposit. You can probably already see where this one is going. In the case of the huge deposit, which is a case I literally had on my desk that I dealt with, the client comes to me and says, I had my first deal. I'm really excited about it, but I haven't heard from my contractor. And I thought, well, that's a call I get not that infrequently. What happened? Oh, well, we signed an agreement. That's great. It was a $65,000 job, and he asked for a non-refundable deposit of $50,000. Right? So I could read the rest of my notes, but I think you guys know where this goes. It gets a little worse because he didn't just take the money. He actually did horrible, horrible work, which when we were able to sift it out and try to discern the value of the work, appeared to be approximately $7,000 in value of work, but also ended up costing her about $100,000 to repair it. So, no, it's exciting. But this is the kind of, so this is the scenario that puts people like this on the phone, and these are the kind of problems that we're trying to preempt. And so I think, I'm going to leave that there. I'm going to leave that hanging with you. But that was a real problem. The second horror story deals with a flipper who, in good faith, hired a builder, a contractor to come in. The property was developed. It didn't go great, but it was ultimately finished. And the property was then sold by the flipper to an end buyer. What happened was there were problems with the construction. And the end buyer, a family, was very unhappy about that. And they came back to the flipper and they said, hey, what's going on with the construction? We need some things fixed. And they said, well, you got to talk to the builder. This is called the case of the phantom warranty, because the phantom warranty, because there was no warranty. And so one of the things that I ask flippers to think about is, if you're not the person swinging the hammer, if you're not the person building the project, you may have some real things to think about if you're intending to sell this product, which is someone else's product, to an end user. Let me see. So we'll get back to that one as well. That ended in what is now litigation. The third scenario is one that I have encountered multiple times, and it is these names I've chosen are very arbitrary, guys. But we're calling it the case of the shaky mechanics liens. Shaky mechanics liens are bad for everybody, and we'll talk about what a mechanics lien is and why you don't want them. But when they've come to me, it's been a flipper who owns a house, who's developing a house, and has a disgruntled contractor who then files a mechanics lien against the house. Now, here's what's happened in my office, in my experience. The mechanics lien is filed improperly, so I'm able to have it discharged fairly easily. So to my contractors, and I ask for a raise of hands, and they're either too afraid to do that or they're just not here. My contractors, I would say, if you're going to assert a mechanics lien and you're not sure exactly how that works, call somebody like me or call a construction lawyer. But to a flipper, it's a whole nother situation, because there is, in Pennsylvania, a very complex, nuanced framework for mechanics liens, how they're asserted, how they're waived, and how that plays into your construction agreement that's in place here. So from both sides, I think that's a cautionary tale. So I've got my huge deposit, my phantom warranty, and my shaky mechanics liens. So with those horror stories in place, I'm going to take you through the major, what I think are some of the major provisions in the agreement that we drafted, talk a little bit about some of the underlying, you know what I think might be really fun, though? Don, I can just, right? Does anybody have any horror stories about contractors? Do we have a couple minutes for that? Can I? I mean, does anybody have anything that they think would be useful for the group to hear? Those are the kinds of stories that I've tried to gather. If not, that's fine.
Anybody? All right. Wait. Are you speaking? Do you want to say something? All right. Yeah. Okay. All right. Lee, go ahead. I'm sure somebody has something to say something later.
So, let's begin. that was the exciting part. This is the legalese, so I'm going to try really hard to keep it in plain English. If you do have questions, I'm going to shy away from the don't ask them option and just say raise your hand. I'll try to be as structured as I can in answering them, and we'll go through some of these provisions and see where that takes us. This is a disclaimer.
This is the one that you wrote.
This is the disclaimer that I wrote. This disclaimer that I wrote is on the document that you'll receive. I'm not going to read it out loud. I trust you all understand that I'm not, in my capacity, standing here in front of these very bright lights, your personal attorney, giving you custom tailored advice. Oh, I had a slide for that too. All right, well, we skipped ahead. So we start our consideration of a contractor contract with what is the project that we are embarking upon? What is it that the contractor is going to be doing for us? And that, it turns out, is probably a more complicated question than a lot of times people realize. What we arrived at in our conversations is that this is almost as critical as vetting your contractor at the outset. And what I think repeated on the call as the attorney is I'm typically not involved in drafting the scope of work. I'm not the guy that knows where to put the whatever it is, the wires, whatever. But the key takeaway from the scope of work is that it should be as detailed as possible. Is that fair? It should be as detailed as possible so that if there's a deviation, it can be plainly identified. And if there's any other kind of change order that's required, we'll discuss that. It can be easily implemented. One thing that was brought up on our conversation about scopes of work that I found useful, that I think a newer investor may find useful, is the concept of having the flipper themselves put the scope of work together instead of having the contractor do it, so that it can be presented to different contractors, so that what you're getting is a comparative shopping from different service providers, and you have a standardized sort of set of scope of work, I should say. So that's the piece on the scope of work. You will see in the agreement that's available to you, I believe there's both an exemplar, like a filled out scope of work that shows 123 Main Street or something, and then a blank one that is editable for your use if you wish to.
Just a blank one. I left the other one out.
Just a blank one? Okay. So, but it has all the fields that are relevant. It was provided by one of the contributors, and was determined by the group to be a good candidate for use by people in this project. Did you want to, by all means? There's significant language throughout the contractor contract that you'll see about the distinction between your contractor being either an independent contractor or your employee. This can be a very complex consideration. For a newer flipper, it strikes me that this is going to be less of a problem for you. There are a ton of factors depending on which body is sort of determining and considering this issue. They're enumerated in the agreement themselves in one of the end notes. I think it's end note 3. So I'm not going to belabor that point now. What I would give everyone a heads up about is if you find yourself in the privileged position of doing really well with this, and you have a contractor and you've developed a fabulous, fruitful relationship, and it's going on and it's continuing, and he begins to work for you and he's only working for you, that's probably a really good sign that he may be becoming an employee of yours, and this is an issue that's rising in importance for you.
Explain the difficulty of employee versus contractor relationship, pros and cons of each.
With an independent contractor, you have someone who's working for you that's essentially a hired gun. They're, in every respect, a free agent. They're responsible for their own, all of their own costs and expenses, et cetera. I think the main burden with having an employee is that you're now responsible for their benefits. And there are also, if the relationship is improperly characterized, there are consequences to that, according to the state and possibly the federal agencies. So it can be a complicated situation. It can be a complex set of factors to apply. Like I said, for most of the newer flippers, I don't think that it will be. I can't think of an issue where I've seen it exceed that threshold. I know on our calls we kind of discussed some of this. Does anyone have anything they wanted to?
Hold on, Matt. Matt, grab the mic, please.
The only thing I want to add there is just, when you have someone that's doing work only for you, like Lee said, they can be classified as an employee. If that happens, you would be responsible for their workers' compensation. The fines for workers' comp, I think, are $2,000 a day per employee. So if they get to a point where they may be considered an employee, could be some significant fines. If they're injured, there could be some issues that arise as far as workers' comp. So that was just one thing.
Right.
Good, but as long as the person is clearly not just working for you, and as long as you're clearly not defining their hours, then you don't have an issue with them being an employee. The IRS sets those rules for being an employee. Frankly, I don't think anyone has to worry about that with a contractor unless you're doing multiple jobs for just you. Now you got to be careful.
Please.
Grab the mic, please.
What would be the situation where you've hired the general contractor and the general contractor has been working a lot for you, and now the question is, are they an employee or not? Well, what happens when they're hiring subs? How does that roll down? Whereas the sub can just work forever who they want, and the subs are the independent contractor, and then the general may be an employee.
Are you asking whether the subs could potentially be considered employees of you through the relationship with the general contractor?
Yes.
I would think it would be the same factor test. Off the top of my head, I'm not really sure, but I would think the factor test would apply between the general contractor and the sub. So at the back of the construction agreement, there are, and we kind of touched on these, and Larry enumerated it to some extent. The IRS, the state of Pennsylvania has laid out, and the courts have also laid out different factors that they weigh. It's not like a black and white test. You can't say, oh, well, that person is definitely an employee and that person's definitely an independent contractor. Actually, I think probably a fabulous and timely example of this is right now, Uber and Lyft are presently litigating this very issue. So the question is, I have 12 factors from the IRS, which I don't think I should be in the business right now of implementing. I'm happy to discuss this at a later point. There's 12 factors that you could apply to an Uber driver, and right now there's a real legal question as to whether or not that makes the Uber driver an employee of the Uber company or are they an independent contractor. And the Uber has, I believe, said publicly, if it is adjudicated that they are employees, essentially our business model is eviscerated because of the burdens that we're talking about. We'll see. It's on tape, so if you're right, you're right. So I'm inclined to. I think we've touched on the issues here. I think what I'd invite everybody to do is to take a look at the agreement, to take a look at the factors that are laid out in the endnotes. My email's available. I'm happy to discuss this stuff. And kind of swing into the next. This is exactly how our calls kind of went, and it's exciting. So I'll take it to the next contract time. This is something also about which we had significant conversation, specifically the way the contract was set up after our negotiations, is that we placed a hard deadline in the agreement, meaning that the scope of work that we delineated on the first slide is going to be done by X date, a hard date. That being said, it's going to be subject to change orders, which means the parties can in good faith change that. There are some pieces of the change order I'm going to talk about a little further down that are important, but I wanted to just talk about the temporal aspect of this contract, which is we're doing a project, it's going to take this long. If it's not done, then we get to the third component, which is a possible penalty to the contractor, which I believe there was some kind of tension and controversy about, because if you're a contractor, that may be something you don't wish to agree to. What we settled on was, I believe, something like 10 days or something reasonable, so that if there's a legitimate reason that the contractor has to be behind schedule, then that's okay. We tried to represent the contractor's interests as well and make sure this wasn't an unreasonable burden on them just to sign this agreement. So we've got a hard deadline. If something really needs to be changed, it can be changed by agreement of the parties. If it's not changed and the deadline is breached, the contractor's got a problem because he did sign this contract. He agreed it was going to be done by that time, didn't do it. There are penalties to the contractor for that. So ultimately, I think on balance, that's protective of the interests of a flipper.
But we really need to get a little more into the change order discussion.
It's the fourth slide.
Next slide, okay.
Highly anticipated change order slide. We're just building it up. So this is contract price, which I think is on its own merit a fairly exciting slide. There you have it. So, but the contract price is obviously a crucial, what we lawyers call material component of the contract. What we've got here is the aggregate contract price. In my huge deposit case, it was $65,000 for the whole project. Okay, so that's the amount that at the end, if you add every payment up, that's how much the scope of work is going to cost. The question that triggered this meeting to begin with and snowballed this whole thing is, what deposit do you put down at the beginning? And you've got some contractors that will say, I will do a scope of work for 100% upfront. On the other side, you've got flippers that say, I will pay you nothing until it's done. So you've got to find a middle ground. We did our best to do that. We left it blank so that the parties can negotiate a particular portion down, 10, 20%, something to make the contractor feel secure. However, because it felt to us that the possibility of a runaway contractor was one of the major exposures to a novel flipper especially, we created a box which you can elect. And that box, if elected, creates a provision where that 10, 20%, whatever that deposit is, goes into an escrow account. And now you have a third party that has the deposit money. Now, I'm a lawyer, and I know that could be a lot. I know it can be a lot. It can be a big problem. But if you are looking, I mean administratively, it could just be a lot of kind of like dotting I's and crossing T's. But if you're looking to establish a relationship with a contractor that you can't otherwise vet that well for the long term, it might be a good way to do that. It's electable. You cannot elect it. But we felt it was a possible middle ground that could balance the interests of all the parties involved.
Can I comment on that,
Please.
Lee? So the idea was that at least during some of our discussions, that the contractor wasn't so, I don't want to overspeak here, but that the contractor was not specifically worried about getting the money up front, but rather having trust in the flipper that the money will be there when the work is done, or at the appropriate time. So it's more the trust factor, especially with a new relationship. So the way to get around the trust factor was to make sure that the money is there, but it's in the hands of a third party with all the provisions about how it gets released. So there's no doubt at all that there's actually $30,000, $40,000, $50,000, whatever it might be, physically somewhere and not in some mystical bank account that may or may not exist. So it was the trust factor that drove us to create this escrow model.
I agree with that. And what I'm trying to do is I try, it's against my nature, I try not to over-lawyer these things. I try to realize that people aren't lawyers and they shouldn't be lawyers, and these things should develop organically, and lawyers sometimes get in the way. Sometimes we help. This is one of these provisions that if you implement it every time, I think it can get in the way. I see people's heads shaking. I get it. I know. I put the box in there for that reason. But I also think there's a time and a place, and yeah, don't check the box or check the box. It's fine. So with that being said, if we're all right with that, I think it's time to unveil change orders. I know there's a lot of tension in the room. Yes, it's happening.
We're filling the room just for you.
Ah, I see. Wow. So we've established that we've got a scope of work, a hard deadline by which it needs to be done, and guess what? Things happen. Things go sideways, things change. Environmentally, they change. With the government, they change. With style, they change. With money, they change. The contractor, they change. Whatever it is. When that happens, it's easy to say, well, we're going to have a change order. That sounds nice. What we've done in our contractor agreement is actually provide to you an example of a change order. It provides these material details that should all be in your change order. The reason they should all be there is because I have seen on my desk issues where I've got a change order signed by one party. That has no value. And what it has value for one thing, it confuses the hell out of everybody. Because one party thinks that the deadline has changed or the scope has changed, but it hasn't changed. So when we have a change order, I'm going to recommend very strongly, and you'll see this throughout the written piece, all of the interested parties sign it so that there's an actual literal meeting of the minds on the same page. And through our conversations, we came up with something that I also think is a really practically important aspect of this, which is take that change order and post it at the site. Maybe that's not that novel. I'm not at these sites all the time. I think that way you've got everybody's signature and you've got visibility, not just with the contractor, with your subs that are on site, with any other parties that may be contributing to the way this project is going to evolve. And I hope it met everyone's expectations. That's change orders.
Bill, did you want to say something? Oh, just scratching your ear? Okay.
In addition to the deposit conversation that we had, another way to tip the scales of the balance of interest, tweak them a little bit, is to talk about how the framework for the payment to the contractor is going to go. We've already found out if you drop a lump of gold, it may disappear and that may be it. The way that we set this contract up that you'll see is through a predetermined schedule of payment, typically called a draw schedule. It should correspond with discernible milestones that are performance-based and easily identifiable. And they get inspected by the owner, and once they are, the money can be released to the contractor. What you will see in this is we went a step further. We put some language in here to try to make to try to engender as much civility between the parties and good nature as we could. There's a language in there that says that the parties will, if there's any dispute as to whether or not an item has been completed, they'll get together in good faith and they'll talk that over and discuss that. And then there are two potentially controversial items. I'll find out if that's true. The first is called retainage, and I'll talk about that. So retainage would be if I have, let's say, 4 payments of $10 each, so I have an aggregate of $40. Everybody with me? Math is not my strong suit. If I had a 20% retainage, then for each payment of $10 that were to go to my contractor, the retainage would be $2. I think I did that math right. So 20% of 10 is $2. So that $2 on each payment would not go to the contractor. It would be retained by the owner in order to create an escalating system of incentives for the contractor to complete the project. Because on each payment, there's a little bit that's being withheld. And so the contractor knows he's going to get his last payment, but he's also going to get his retainage at the very end. And so this is sort of a way to keep waving that carrot to get over the finish line. It seems to mesh with human nature that might work. It also seems that there are contractors that will never go for that. It's going to be up to the parties, but I think it's something that, as a room full of flippers, you can consider using, and some will.
Use the microphone, please.
Does that have to be put in an escrow account? Because basically, they have earned it. That's why I'm saying that.
Does it have to be? No.
Okay.
Should it be? I don't know. Will it be? It can be. We put a box in here to elect it. I believe that it can go into escrow. But it's subject to the parties. And that's the beauty of a contract, is it's a reflection of what the parties agree to and intend. No, this is how I like to be waterboarded, actually, with bright lights.
Please,
You see that? Great. This isn't on camera, at least, so that's good.
Yeah, please use the mic so we can record your wisdom.
I told him to take his jacket off because he's sweating.
Yeah, it's just a little heckling. It's not a big deal. So, with regard to the final payment happens under the agreement that we wrote under the following conditions. First of all, if there's a punch list or any other sort of residual items that need to be completed by the contractor, those are completed. Second, the contractor provides any kind of lien releases, documentation that is required under this agreement. You'll see that, and we'll talk a little bit about what those are. And it's at that time also, with the final payment, if this retainage concept is elected, that those will be allocated to the contractor. So that's payment procedures.
Did we get to the section about materials yet?
We have not.
Okay.
Sir?
Grab a mic, Steve, right here.
So if the general contractor has hired subcontractors, how do we know that progress payments have been allocated to subs as they've proceeded to complete work and they're no longer on site anymore? Say electricians and plumbers or do their rough-ins, and that's the extent of their work, perhaps.
One of the elements that is in this agreement is a partial release of waivers, which is a representation by the contractor that upon each of the draws, all of the work that's been allocated in the scope of work to that juncture has been completed.
But there's no guarantee that the sub has gotten his money and that the sub will happily waive their lien.
The agreement extends to the subs, requires all of those things. You're not wrong. It's could potentially be an issue.
That's a really good idea. I mean, a really important thing. I'm wondering if there's a mechanism that people should build in that ensures that subcontractors have in fact been paid by the contractor.
So,
I mean,
please.
On some of the contracts that I do, I actually have the homeowner pay the subs directly so that there's no question about their payment so long as the inspection has been agreed to.
As a month. Are you suggesting that the partial release of lien should be given to the contractor, the general contractor, after each draw?
Correct.
Okay.
Before he gets paid.
Or, right.
I should mention, so under Pennsylvania law, and this was asked by someone upon registration, they were asking about how to, this may have been your question, specifically how to ensure that a subcontractor has waived or may waive their lien right. I looked into this, and it appears that the law changed not so long ago. It used to be that it could be waived by virtue of the provision of a notice of lien waiver. It's now changed where the general contractor would have to put up a payment bond to ensure payment to those subcontractors. That's what I found on that issue.
Use the mic, please.
Couple times when I've had big roofs completely replaced or whatever, and the expense for the material's been in the $10, $20, $30,000 range, I insist to the contractor that I pay the supplier directly. And that way, I don't have to worry about a supplier coming after me. I think technically Home Depot could come after you if you don't pay them.
That seems the most plausible way to address this potential exposure is to insist on identification by the contractor of who the subs would be, and then, as you suggested, to pay them directly.
Grab the mic, please.
Hello?
Okay.
The question was, should there be wordage in the contract that you're going to be paying the subcontractor?
If that's the scenario, absolutely.
Okay.
And yes.
Well, another thing that happens there, if the contractor's telling the sub he's not getting paid, the owner didn't pay him, and in a sense he did, the sub will contact the owner to say, hey, I didn't get paid because he said you didn't pay him. And then you know what's going on.
Contractor's representation is a slide for lawyers. I think I have one in the audience. The representations made by the contractor are essentially things the contractor are stating are true so that if there's a problem, you could sue them. Pretty much lawyers care about this and no one else until they have to sue the other party. So with that being said, the provision in the agreement is fairly narrow, but that's when you see representation in agreement, that's what you're looking at. There is a provision to define contract docs. This slide is essentially telling us that within the contract, we're defining that the contract is larger than merely the four corners of the contract you're seeing. It includes those change orders as they may be included. It includes the scope of work as it may later be appended or changed, and any other documents that may be relevant to the process. All right, now this one is busy. This is probably the meat of the contract itself. You will see a paragraph that goes on for quite some time called Contractor's Responsibilities. As the flipper, this is one of the most important things for you to concern yourself with. What is it that I'm buying? Essentially what you will see will answer some of the questions that we've already discussed. It will require your contractor to retain adequate personnel who are insured, to have insurance, to make sure that they do exactly what they say they're going to do. There are 16 sub-paragraphs under this paragraph, which I will not go through because like 2 of you will remain awake if I make it to the end. I found 3 I think are worth emphasizing that I'll go over, and you know I think that's a good start in terms of what are the crucial pieces. The first one that I highlighted is a question about who is furnishing the items which are part and parcel of the scope of work. Don had brought this up earlier, so if you wanted to say anything, feel free.
Nope, go right ahead.
So we talked a great deal, and I'd actually like to hear from the panel about this because, candidly, I'm in my office. I'm not ordering the sink. I'm just not. I think that there's great value in hearing from the guys that are doing this about which items are being purchased, which items are being paid for, and who is delivering the items to the site. We've created a sort of modular approach where for each of the items, I believe it is, it can be elected. Let me just get this right for you. It says for each of those tasks, which of the parties will be handling them. And that way there is some flexibility in if the owner wants to maintain more control, they want to go to, let's say it's Home Depot, pick the sink out, make sure that sink gets paid for so there's no lien. Buy that sink, bring that sink to the place. That is exactly how this agreement is structured, to give you that flexibility. Perhaps the flipper doesn't feel like doing that. The next piece has to do with, well, before I go ahead, did anybody want to add anything any of the contributors want to add anything to that? Because I know that's a major piece, sort of logistically, of how these deals proceed.
I buy 90% of the stuff. I buy it and get it on site.
doing it that way, that's how it should be done.
No.
No, I mean that. I do.
There's 20 flippers in here, and everybody has a different way of doing things. That works for me. It might not work for you, might not work for them, but it works for me.
All right.
Okay, don't go there.
Sorry, Bill. Yes, sir.
So if you take on the responsibility of picking up 90% of the materials and you hold up the job, at the end, the flipper or the whoever says, well, you didn't have things on the job in time. That's why I'm late.
Explain that to you. Okay? When I get the place under contract, if I buy it off the MLS or whatever, I get right in there and I put my scope of work together. If I can get in there, if there's nobody in there, I put it all together. I've got a spreadsheet because I've done so many flips of everything on there from Home Depot, okay? I buy a lot of stuff at Home Depot. I go in there and I buy it. I get it all bid out through the bid room. I get it all delivered at one time. Not to say something isn't going to be missing, but there's always something there where you can make your next jump or your next move where I don't have to run out and get him a piece of pipe or a piece of that. So that material's there. Sometimes on a smaller place, it can be a pain in the neck. But if you deal enough with Home Depot, you can split your order and they'll hold it and they'll deliver partial. And then like you don't want the hardwood floor there at that time because you're demoing and doing stuff like that. And that's, like I say, that's how I do it. And also, I don't have a general contractor on the job. I manage the job myself. I bring the subs in. So I'm pretty hands-on. I'm there a lot. I'm there a lot, and I can foresee a problem as he's working coming up. And if I got to go get something, I can get it. And the whole key to this whole thing, if you get the right contractor and a good contractor, 90% of these problems you don't even have to deal with. And that's all I can say. So,
but the example that you used, where you're late delivering the materials, then that should go into the change order and not be the responsibility of the contractor. So you mutually agree that you were 10 days late or whatever, and you're 10 days late, and that just adds to the conclusion or to the deadline. And so if there are penalties involved, those 10 days don't get penalized. Does that make sense?
I think we all realize that when a contractor tells us it's going to take 60 days, he really means 90. So I pad that in anyway. So if I've got the 30 days padding plus the extra 10 days, I may or may not need to do a change order. I may still be on schedule. You guys all agree with this? 60 turns into 90 before you even start. So keep it in mind. Don't be unrealistic with yourself or with your contractor.
We had one more remark from the contributors. I think this is dealing with, you said down payments?
Down payments.
Please.
Sometimes you're not hiring a general contractor. Sometimes you just
A little closer, please.
Sometimes you just need to hire a particular trade. And a lot of people may not know this, and it's kind of important. Any contract over $5,000 in Pennsylvania, you cannot ask for more than a third down. So if a contractor is telling you on a $6,000 job that he wants half, or any contract over $5,000, legally he can't take more than third down unless there are special order items on that contract. And this came up because of the $1 million flip question. The electrician walked with a certain amount of money, and it was a big job, and I would have thought something like that would have been known to most contractors or flippers, and it's not. So keep that in mind if you're hiring contractors for something over $5,000.
That's legality versus reality. The reality is somebody still gives it.
I'm sorry, does this include supplies as well, or just for the work?
This includes the whole contract price. Now, if it's a special order item,
Closer to the mic.
if it's a special order item, they can ask for that. They can ask for that additional monies, but generally, it's the total contract price. Anything over $5,000, they can't ask for anything more than a third.
What Kenny had just said there, this is all in Pennsylvania's Home Improvement Contractor Act. The thing is, there are certain people who are not going to be covered by that act, and it has limitations on commercial activities. So if you own multiple properties, for example, you no longer fall under coverage for that. You don't have the protections. So just, it's not guaranteed. However, if you only own one property, it's your first job, yeah, you're covered.
All right. So the contractor has a lot of responsibilities. I appreciate that pit stop. One of the next major items that I wanted to highlight in here that we had, I think, a good deal of conversation about on our calls is the question of permits. And you'll see, and I think it's standard, I think it's market practice, your contractor should be the entity pulling the permits. Under his name, his license, that should be how that looks, and that's in this agreement. And the last piece I wanted to bring up, the last piece deals with warranties. I told you about the case of the phantom warranty. In our agreement, what you'll see is the provision which would have, bless you, which would have mooted and resolved that matter. There's a provision in this agreement that says the contractor, if this provision is checked, agrees to provide a warranty to the next buyer, to the end buyer of the property. You can take a look at that in the agreement, but it is something which would have prevented a situation where you're a flipper, you hire John Q. Contractor, John Q. Contractor offers you a warranty. Then you sell the house to a family. The family has defects in the house. John Q. is nowhere to be found, and you're potentially on the hook for it. This transfers his warranty to them. And if I'm a flipper, this is something that's very important to me. If you can't get a contractor to agree to it, or you don't like it, consider the issue. I think that's the main takeaway from this, is that this is something, a scenario that's worth thinking about. So with that being said, I'm going to switch to the next slide, and I have a cameo. I would like to reintroduce to you Matthew Heller of Brown & Brown. Matt, I have specifically asked to chime in on the insurance provision. They should be able to pass one down to you. Matt did a fabulous job. I have, whether it's the burden or the benefit of talking to a lot of insurance people, Matt did the best job I've ever heard of breaking down the various coverages in their finest detail, but also doing it in a way that we can all understand. So with that being said, I'm going to kick it to him to talk a little bit about some of the coverages that are involved in this agreement. And here's a copy of the agreement.
You want to come up front, Matt, or do you want to sit at your chair?
Okay, so I'll start by just kind of
Try not to
explaining
get too-
why.
Matt, excuse me, Matt.
I'm sorry.
Don't stand too close to the speaker, which is right by your left,
Oh,
right
okay.
shoulder.
I'll come up.
Get some feedback there.
So I want to start by just kind of high level explaining why this piece in your contract is so critical. Because at the end of the day, right, we have this contract. What happens if there's a dispute? What if a contractor doesn't abide by the terms of this agreement, right? What happens? Typically, right, there may be some litigation. And if that happens, typically these contractors that you might be dealing with, you know, they might not be asset heavy. There may not be a ton for you to go after ultimately if there is a dispute, if they don't abide by the terms of the agreement. So that's where insurance comes into play. And that's why it's so critical that, you know, you spell out sort of exactly what your contractor has as far as insurance, because this gives you an avenue if something does happen to collect, right? So I want to start by just talking through sort of the contractor's insurance and what you should be looking for there. A lot of newbie investors that I've spoken with, they may have a little basic understanding of sort of what they should be looking for, but a lot of times, they're just asking for a copy of their certificate from the contractor that shows they have insurance. Maybe they don't have elements like, insurance requirements in their contracts that actually require them via the contract to hold certain insurance. So I want to start by talking about the contractor's insurance and what you should be looking for there. So in a typical arrangement, as the owner, you have some exposure. Really, a lot of it's going to be, your standard slip and falls. Someone's walking by the property, they, slip and fall on a crack in the sidewalk and sue you, something like that. So that, as an owner, you have some premise liability. That's what they call that. And additionally, as the contractor, they're the ones actually doing the work. Their exposure is for the construction operations. So a lot of times, as an owner, you'll get the insurance that a lot of you may have heard of, builder's risk insurance for the property while it's being rehabbed, and some liability insurance as well. Liability insurance that you're getting as the owner, that we've spelled out in this contract to make it clear sort of who's responsible for what, is covering your interest as the owner. So it's going to cover your basic premise liability, and it's going to protect your investment. The contractor, however, has a different level of exposure. And we spoke before about hiring subs directly versus using a GC and hiring subs. I just want to make a point there. There is added exposure to you by hiring subs directly. When you hire subs directly, there's no general contractor as a buffer in that contract. So any sort of construction, so let's say, you hire, let's say, you're building a deck on your investment property. It's a roof deck, and you hire someone to do some railing work around the property. Let's say that everything goes to plan, project gets completed, and ultimately you sell the property to a buyer. If, let's say, the buyer is sitting on that roof and let's say they're leaning against the railing gives out, and that person falls 3 stories off the property. Just a hypothetical here. Not to say this would happen, right? It's a very, very difficult,
There's 3 different than 2.
So let's, using that hypothetical, right? If you hired your sub directly, maybe they have the right insurance, and you're ultimately probably going to get brought into that suit as the owner. Deepest pocket, you may have heard that term. And as the owner, right, there's less of a buffer there for you to sort of get dragged into that claim. Obviously there's some third party, litigation that might happen to you as the owner. And basically, if you're hiring that sub directly, there could be a potential higher level of exposure. If there's a GC there, and there's requirements to that GC, and those requirements are passing down to the sub, then there's sort of a buffer. You may have the GC's insurance as well to help sort of buffer your insurance. So ultimately, at the end of the day, it can make sense to hire your own subs, but there is a higher level of exposure. So I just wanted to bring that up also. As far as sort of high level, how you should require your contractors to have insurance and what you should be looking for. Again, they need to have general liability insurance to cover their construction exposure, because your insurance that you get isn't going to cover that for the reasons I mentioned. You're just getting sort of the premise liability exposure. That's sort of what your exposure is as the owner. The contractor, right, you're going to want to make sure that they have general liability insurance to cover their construction exposure. You want it to be primary and non-contributory, which means that their insurance is primary, your insurance doesn't contribute to their insurance. You want to be named an additional insured on their policy, not just for your occurrence limit, which is any bodily injury or property damage, but what's called completed operations as well. In the example I gave you, where there's a railing contractor, doing work, they sell the property, there's a new the new buyer's living there, right? The work's been completed. So at that point, if you don't have completed operations coverage, in addition to what's called your just occurrence limit, which is just, let's say $1 million, which is typically a standard, then you're not going to have coverage for anything that happens after the property's sold. So you want to make sure that you're asking for certificates of insurance, that you're named an additional insured on a primary and non-contributory basis for both ongoing, the work while it's being done, and then completed ops, after the work's been done, because there's still liability exposure to you after the project's been completed and you've sold it, in that example with the railing. So, that said, the purpose of this and the reason it's so critical is to, outline specifically contractor's responsible for this, the owner's responsible for this, having it written in the contract, and really, again, for the reason being, if there is a breach of contract, they don't abide by the terms, that there is some avenue, obviously only if it's insurable, but it just gives you another avenue to go after them if there's an issue. So, that's sort of high level what you should be looking for. There's other insurance that you can get if you don't trust let's say because at the end of the day, right, has anyone seen a certificate of insurance before? Is anyone familiar with what that looks like? It's a one-page document. That only tells you so much, right? It tells you you have $1 million in coverage, but what it doesn't tell you is, what if there's a limitation on residential construction where or there's a construction exclusion, or there's so many different terms and conditions that you can find in insurance policy that you won't find on your certificate, where as an owner, you may want to sort of have a backup, right? What if the contractor's insurance doesn't cover me the way I need it to? You can get additional insurance as an owner to sort of pick up the construction operations. For these types of projects, it may or may not be feasible, but if you're looking at a flip where you're going to make, for example, I don't know, 25 to 75,000, and maybe you pay another $2,000 for this insurance to eliminate a potential maybe $30,000 issue down the road, is it worth it? So those are sort of the things that you have to think about, when you decide sort of what insurance you want, but there's a lot of things that you can do to sort of transfer the risk down to the contractor, yes.
Hold on, let's get the mic.
Here as a property owner is workman's comp, because if one of the contractor's employees falls off the roof, that's probably your biggest exposure, I think. How do you cover yourself in that regard? Is there a certificate of insurance for workman's comp, or how do you know the employees that he has brought on that day are covered and don't end up doing that?
So in addition to general liability, and some of this, is this, Lee, is this the only section, or is there another? Yeah, so, part of this is, in addition to general liability, you want to make sure that they have workers' comp if they have employees. Obviously, if they don't have employees or they're a sole proprietor, they're going to tell you that. And if that's the case, the liability coverage that you procure in addition to that I just mentioned can protect you from those sorts of things. Because if they sue, you'll get coverage for that. But otherwise, if they have employees, you want to require workers' comp. They have their own company cars, commercial auto. And one of the things that a lot of people don't think about is what's called hired non-owned. So if you have a contractor and, let's say they're driving, or let's say their employees are driving their own personal vehicles to a job site, commercial auto coverage isn't going to cover, those sorts of things. It's going to be what's called hired non-owned coverage. So just, there's a lot of nuance to this, and it really depends on the project size. And it's, really critical to, number one, make sure there's insurance requirement provisions in your contract. But number two, consult with your insurance broker or advisor on, what specifically, depending on the job and what you're doing, should be included in that contract. Because, for a single family flip, you might ask for certain requirements. For, let's say, multifamily ground up project, you might ask for others. So, moral of the story is insurance is critical, and consult with your insurance broker to help with those requirements.
You've requested the certificate and requested them to get all these insurances. How do you verify that they actually do have what you've requested?
So one of the things you can do, and I don't know if we have it in this contract, but I've seen it in other contracts, and it's a possibility if that's a concern, is that you can make payment contingent on a valid certificate of insurance that checks the boxes of what you're looking for. So a lot of owners will have a sample certificate on file, and they'll send it to their contractor and say, this is what it should look like based on the requirements we spelled out. And then you have something in your hands that you can compare their certificate to and say, okay, this checks all the boxes here, there, so that's one way. And I know some project owners will do, maybe a contingency where it's, we're not going to, cut you that check until you show us a valid certificate. Yeah, and that's actually a really great point too, because
repeat the point. Repeat it, please.
I've actually had customers just call my agent to verify.
Yeah, that's one way. You get the certificate direct from the agent. If they give you the certificate, that's their errors and omissions on the line, the agent. So you can sue the agent if something happens. So that a lot of times that's a good way to go. Get the certificate straight from the agent. There, you'll know there's no funny business, because I've seen doctored certificates, and I've seen it all. So
I have a question. We are lenders, and I always see the certificate of insurance before closing.
Sure.
So what should I look for in this? Should I look for the specific property address on the certificate, or should I look for the borrower's name in the certificate as well as our lending entity on the contract, on the certificate, and on the contractor's insurance? I'm asking about the contractors.
The property won't be on there for the contractors.
Okay, so the property address will not be on the contractor's insurance.
Yeah, because
would we be looking for ourselves as lenders to be named as additional insured on the contractors? Yeah.
Not necessarily.
Okay, and what about the owner of the property?
The owner, yes.
The owner should be named on the contractors.
You should be named on the owner's insurance.
Yes, we are.
Yeah.
But in the contractor's insurance?
Oh, and the contractor's not necessarily.
Okay.
Yeah,
we just need to see the contractor's insurance. They have the appropriate liability insurance.
Yeah.
Okay.
Right, because there's no sort of insurable interest as the lender on the contractor's policy.
Okay.
But it does make sense for the reasons you mentioned to verify their insurance, because that's the easy way for the owner to get dragged into something, that, could impact your
right, our interest.
Yeah,
right.
Yeah.
Okay. Thank you.
Matt,
explain.
My favorite term is additional interest, not additional insured. So can she be named additional interest on the contractor's policy?
Not on the contractor's policy.
That is additional interest?
No.
Okay, so they can't even say And she would be notified if the policy is terminated or anything?
Not on the contractors.
Okay.
Unless the contractor, based on the insurance, is responsible for the builder's risk and premise liability, which you see sometimes, but it's rare. It's usually the owner that's responsible.
I mean, from my understanding, additional interest doesn't get paid. They just get notified.
Right. The check would go to the named insured,
Right,
which would
right.
be the
Okay.
owner. Yeah. And then they would get notified. Yeah.
You're named on the owner's policy, but you're not named on the contractor.
If you're a lost payee,
Right, that's totally different.
then you're getting the check.
Yeah, that's totally different.
Right.
Okay.
So Matt, explain the difference between lost payee and additional insured.
Sure. Yeah.
You knew that was coming.
Yeah.
Additional interest.
So additional insured is relevant to a general liability policy. So basically, you're not the named insured, which is the person that controls the policy, but you're an additional insured on their policy. So you may not get the same broad level of coverage that you would get if you were the named insured, but you're going to get, you really would have to look at the endorsement on the policy to determine how broad or narrow the coverage will be for you. But that's what an additional insured endorsement is. Lost payee is relevant if you're a lender or mortgage company where you have an insurable interest in the property and you're going to be paid for a loss, right? So if there's a loss, rather than cut a check to the owner, they cut the check to the lost payee. So it's usually a requirement by lenders to help protect their interests. If they're just named an additional interest, for example, then like Larry said, they're not going to get the check's not going to get cut to the lender. They're just an additional interest. So go to the owner, and then it's incumbent on them to handle sort of paying off, the other lien holders, if there are.
Steve, give up the mic, Steve. No, go ahead. You have a question, Steve?
I think it certainly on topic, but a little different than what everyone else was asking. So, should we switch gears? Okay. So, yeah, absolutely, it is. Yes. So, going back to your example of somebody falling off the roof. All right, I'm going to tell you that keeps me up at night. Yeah. It is one of those things that I've thought about. We get builder's risk insurance. The day we sell the property, I call my insurance guy. I tell him, all right, I'm done. I'm out. But 3 months from now, something happens. So I looked around. I called several different insurance brokers. I couldn't find a product that would cover me. Now, I think for that liability, right? So I think in what you said 10 minutes ago or so when you were talking about that, it sounds like you know of a product, and because you had said 25,000, whatever, up to 75, which would be wonderful. But
right, I'm just throwing numbers out there.
Yeah, that's okay.
You know better than I would.
That's okay. So and you had thrown out a number of $2,000 or whatever. So is there a product that of that, as far as our business, we should have that? I don't know. Is it a yearly thing or?
So basically, I mean, it's similar to what a GC would have at the end of the day. So it's basically insurance, owner's interest insurance that covers construction operators. So it exists, right? But a lot of times it's not feasible at this project size. I see people developing larger projects that will look to get this types of insurance. Sometimes just single family, it just doesn't make sense just from the price point and how much it costs and that sort of thing. But there is insurance like that. Typically you're looking at usually at least a $2,500 minimum premium. So that's sort of where you are. In addition, you can get your premise liability on there too, so you can kind of get both.
Right. So if I get that, do I not need builder's risk?
So that's on the liability side. Builder's risk is what protects the investment itself.
Okay.
Yeah.
But why wouldn't we be covered under the contractor's
general liability as an additional insured?
So if that's a part of the contract and you include all of sort of, the terminology I mentioned, should be okay. But I also said that it's, a certificate of insurance can only tell you so much. So you're always holding some of the risk, no matter what you do, for the most part, right? I mean, the only way to truly have control over the situation is to get your own insurance for that exposure. And that's sort of that policy I just mentioned. You can have a reasonable level of protection, but unless you have a full copy of their policy and have your broker review it, there's no way to truly know that it's going to protect you the way you need it to. The contractor's insurance I'm talking about. So that's why it makes sense to get control over the situation by sort of getting your own insurance where you know what you're getting, right? It's your insurance broker. They're telling you, what coverage you're getting, right? You're not just taking a contractor certificate and, say, all right, it has $1 million. I'm additional insured. That's it, right? You know the exclusions, the limitations, all that if it's your policy.
Matt, you haven't talked about the 17 perils. I don't want you to go through all 17, but obviously some of them are relevant, some of them are not, and some of them are optional.
Yeah.
What can you share with us about that?
So,
it's an open-ended question.
Yeah, I mean, so the one thing I'll say is, the highest level of coverage that you can get is what's called special. So, if as an owner, you're always going to want special. If you're doing work in Philly, however, and in urban areas, sometimes you'll have special form, but you're going to get a theft exclusion. So you want to look out for that. But I would always recommend going to get what's called special form coverage and making sure you have theft. In urban areas, it's important sometimes, depending on where you are. I have some clients that want it, some clients that don't. It really just depends on sort of.
I mean, one of the perils is ice loading, for example, and I wonder if that's a common peril or not.
Yeah, so that's, are you referring to weight of snow?
Weight of snow, damaging a roof or something?
Yeah. I mean, you have flat roofs in, Philly, for example.
But that's not in the standard policy, right?
So if you have basic coverage, basic form coverage, it wouldn't be. Broad, it would be covered, and special would be covered.
So I think the message to the audience is ask about the 17 perils and what's relevant to you.
Start with special, and work back. That's usually what I recommend, because what special form is it basically covers anything that's not specifically excluded. So it has to be specifically outlined in the policy for it not to be covered. So if you get special and look at the exclusions and sort of work backwards, you can, that's usually the best way to go.
So Matt's contact information is on the cover page of the construction agreement that you can download. So you can reach out to Matt.
Yeah, if anyone wants a card too, happy to.
Somebody else? Steve, you have a question?
Yes. Go ahead. Until you interrupted, I had a question. Does the contract actually cover anything about waiver of subrogation?
It should. I mentioned it, but I don't know if it's in here. That's a very important thing. Yeah. I mean, it's not you're not necessarily going to have a ton where you really need it as the owner. It's usually the other way around. But I mean, it's definitely important to have. I mean, if you have, because if you think about it, I mean, usually the issues that cause an insurance claim are usually construction related. As it relates to just the builder's risk insurance, I mean, it's hard for the owner to be it's typically the contractor, and they usually want the waiver rather than the owner, because and I'll just, if anyone isn't familiar with waiver of subrogation, let's say you own a rental property and the next door neighbor's house burns down, right? And they cause a ton of smoke damage to your property. Subrogation is basically your insurance carrier going against their insurance carrier to recoup sort of that loss. So as an owner, not necessarily going to be an issue, but as a contractor, you probably would want that included in your policy. But it's definitely important.
One other thing I wanted to point out for the people is workers' comp in Pennsylvania has a search site. You can actually search online. The state has a site where you can actually see if the contractor has it. And if they aren't there, they aren't covered. The site is rather difficult to use in search form, but it's there.
Yeah, it's the Department of Labor and Industry. It's if you look
I actually posted a link on the answer line a couple, I don't know, maybe last year sometime that I posted it when someone asked about roofers and roofers getting coverage for their workers' comp, and you just look it up.
Yeah.
If you don't want to trust them.
Trust but verify.
Of course, the Accord certificate will have a checkbox for that, so you can see that they have it. And the other cool thing about workers' comp, if you do have a general contractor, as he pointed out, the general contractor is on the hook for workers' comp for all the subs on site. So when at the end of the year, the general contractor gets audited and one of his subs didn't have workers' comp insurance, the general contractor has to pay a premium.
Yep.
Because workers' comp is always done in what's called retrospective. So they look backwards to see what you needed at the end of the year. They charge you extra.
Yeah, no, right on. And, the link to that, I mean, if you just look in Google, PA workers' comp lookup, you'll be able to find sort of the search bar to look up any company in PA, whether or not they have comp. So yeah, great point, Steve.
One other question. How long after you've sold the property is the insurance good for?
So, I mean, it really, it's statute, right? I mean, you're looking at on completed 7 years. It depends. I mean, it depends on what it is, but I mean, the max is 7, right, on that. Like, or the, yeah, I don't know. I would say at least 7, but I think that may be a better question for. Yeah, that's what I'm saying. Yeah, but I'm pretty sure construction. No, I'm just talking about the statute of limitations for like a construction completed operations type claim. I think it's 7 years, but I'm not positive. I can get back to you on that, but I believe it's 7.
Any other questions? Or should we thank Matt and re-invite Lee? Right.
But just one more, I'm sorry to go back to that, but if you can spell out, basically, the contractor's completed operations coverage, you can spell out that you wanted to extend out to 7 years or something like that. You can make sure that's written in the contract. So that's how you would make sure that they are abiding by that, for example. But if that's not reasonable, maybe you go 5, maybe you go 2. It just sort of depends on.
Matt, thank you very much. Great job. Let's give Matt a round of applause, please. All right, Lee, you've had a rest now. Let's get with it.
I'm refreshed. Throwing guys off of the 3rd floor. Always great hypos and insurance. I just had a few more legal provisions to discuss. They are none so sexy as the insurance provisions, but I think they are important. We'll finish with those. I'll save the boring legal ones for last so I can see who's really interested. And then we'll finish up with questions. But I'd like to thank Matt again. That was fabulous. Appreciate it. So the next provision after the insurance provision in this agreement is deals with termination. I was just sitting here and I heard a key line that I've gotten used to hearing over the course of our conversations, which is trust but verify. We heard some stories on our calls about flippers who thought they had a great contractor and things were going really well, And it was determined that within a few days to weeks, if the flipper is hands-on enough, they should really have a flavor of whether or not the project scope is being delivered and being delivered timely. And one of the things that we kind of kept coming back to is the fact that if that's not the case and a change order is just not going to cut it and it looks like the relationship is souring, the flipper really needs to cut bait and move on. And this provision permits that. Essentially, the flipper can terminate this contract at will at any time. The contractor must be compensated. This isn't an unfair thing where you're throwing a contractor out. You wouldn't want to do that in an unfair, unequitable way. But this permits the flexibility that a flipper may need in the event that they just have to move on and that's not a good outcome anyway. It's going to interrupt your project, but it's here. The second thing is either of the parties would be able to terminate this agreement if there were a breach, which is something that the flipper should be aware of. If they're not honoring the terms of this contract, we've done our best, as I've tried to convey to everyone, to create a balanced set of terms so a contractor could theoretically hold them accountable in the same way, and that's a bilateral provision for both parties. The next provision includes attorney's fees, so this is a really exciting one. I'm just kidding, I had to. But it actually does, and I actually think there's a point out to which I'm going to jump right to the attorney's fees. I think it's actually important in a pragmatic way because people hate it, attorneys love it, and it's something that figures in a lot of agreements you see. We, after some reasoned discourse, decided to include a provision that specifically says attorney's fees will be paid by the party that loses. And if you think about how that's going to play itself out, it actually works to kind of preempt what would otherwise potentially be frivolous lawsuits. The idea is you're not going to be inclined to bring a lawsuit unless you really think you're going to win. So what we're doing is we're using that provision in a way that creates an environment where the parties will deal as fairly as possible with each other. I'm not going to belabor the other legal terms. I expect eyes to glaze over. They're pure legal terms, and I just can't do it to you guys. You're a very good audience. This, however, is very exciting to me. This is a provision near and dear to my heart, and it's one about which you will see some editorializing by me in the end notes. Essentially, dispute resolution, for those unacquainted, is a term that says, okay, we've got our boxing gloves on, we've got a problem. The contractor, the owner, how are we going to solve this thing? And really, there are three primary channels for submitting your dispute, if you cannot, between yourselves, amicably agree to it. The first is going to court. We all know that. We're not far from one right now. What you'll see in in the end notes in the agreement is kind of a conversation about what it means to go to court, what different courts there are. The amount of money for which you're suing can matter a great deal. For example, if you're suing for less than a certain threshold, you can go to municipal claims court. It's pretty straightforward there. It's like TV court. It really kind of is, for those that haven't been. Secondarily, if it's greater, you can end up in common pleas court, which is like varsity court. There's also a conversation about a compulsory arbitration, which is if the dollar amount is beneath $50,000, you'll end up at something like an expedited but court supervised and appointed track. So that's court. Mediation is an agreement by the parties to submit in good faith their dispute to a neutral third party who will try everything they can do, break arms, bend wills to try to find common ground among the parties. Sometimes it works. Sometimes it works and you don't think it's going to work. And I actually more and more have begun to think mediation is pretty useful. And you can elect mediation. And one of the points I wanted to make tonight is you can elect mediation as a first option, meaning before you go to court or before you elect our next option, you could try to sit down in a room. It probably won't look terribly different than this one at tables and chairs that are not unlike these and be sitting across the table from somebody. Sometimes that can help solve problems. If that fails, then you're either going to go to court, which I just described and you're aware of, or you're going to go to arbitration. And arbitration is mediation, except the mediator, the person sitting to adjudicate the dispute, has binding authority to make a determination. Both mediation and arbitration should be private. They should be typically held in accordance with pretty commonly understood and subscribed to procedural rules. And there are pros and cons to going to court, to arbitration. Mediation is probably the one that you have the least to lose by submitting to. Just a little bit about the distinction between court versus arbitration. Arbitration is actually typically rather expensive. The benefits of it are it can be quicker. There are expedited rules for arbitration, but you're also paying for your own lawyer. You're paying for the neutral third party. You may be paying fees to the arbitration association or whatever the adjudicating body is. And so people sometimes like it. Sometimes people feel religious feelings about arbitration. Court can be, the speed of it can depend on which of the forums you're in, which I described earlier. It depends also if you're in the county versus, I do most of my litigation in Philadelphia. It can be a totally different experience. It's one of these things where if you have a feeling, and you want to agree to that with the contractor, hopefully you don't have to use it. But I think that it's important to know that that issue's out there and that it's a decision that could be important. God forbid you ever have to go down that path. All right, so I'm almost through. This is sort of another encapsulation of just some very kind of esoteric legal things which I think had to be in there. I'm going to, I honestly don't think it'll add a tremendous amount to our conversation now. What I wanted to do at this point is see if the contributors had anything else left on the table, take any questions, and wish everyone a wonderful evening.
Okay, questions? Yes, you were given a piece of paper that you can download it.
Don read it at the beginning, and you were just going to, everyone's supposed to write it down.
So, any questions? Comments, thoughts, criticisms, objections?
No criticisms.
No criticisms. Okay, so let me share this with you. So I've shared this contract with a bunch of people over the last many weeks in preparation for this meeting, and I've gotten a lot of pushback. And the pushback I've gotten is, it's too long, and this contract is too long and too complicated. No contractor that I'm going to work with is going to be bothered even reading it. How do you answer that?
Me?
Yeah.
I've seen contractors sign agreements not dissimilar from this, first of all. So, second of all, I would say this agreement, at the very least, is a starting point for the conversation. I am not telling anybody in here, actually, it's in writing. I did not tell anybody to use this contract. What I am saying is, think about the issues that this contract raises, that this panel brought up and discussed for months and months and months. There hopefully have been some anecdotes shared, questions asked, items raised in the contract that jog your memory. Maybe you take a piece of this language and you add it to whatever you already feel comfortable with. I have no particular dog in the fight or ego as far as whether or not this gets used. That was the purpose of this. The idea is potentially, as we're having these conversations over months and months, we'll be in a room in the Boy Scouts headquarters and we'll be able to share some of our lessons and conversations with the people. And that's my response.
And what's the Boy Scout motto? Be prepared.
Be prepared.
Right.
I just learned it.
I couldn't have made that up. Okay. Anything else? Steve, grab a microphone, please. You weren't here before, Steve, so introduce yourself briefly to Lee, please.
I'll move. That's always Stephen Carmen. Hopefully you all know me. You mean like
I do joint venture funding and investing and all sorts of things. Anything that makes a lot of money quickly that's legal and no risk. So, and it's working. My question is, all right, you went through all these issues, you've broken it into these sections. Did you ever think of doing an outline that says, you know, like this section, here's what we're trying to address?
Hold the mic to your mouth, please, Steve.
In bullet form. So, you know, we forget the legalese, forget the statements, but we're trying to provide an equitable contract that protects the person who's needs to terminate it because the contractor isn't working at the same time paying them what they're due. That type of thing, which you kind of talked about, but just kind of bullets. They are outlining what each section does.
No, we didn't, and I don't mean that in a snarky way. Sort of. I mean, what I would say is, I felt that this was a very organic conversation. These are tough issues, and there's a lot of different stakeholders in them. This is not the be-all, end-all contract. I just said that, and I believe that. I think this is about trying to introduce some of these issues to novel flippers, of which I see a lot of in my office and in my field, who sometimes need, assistance.
I'll rephrase. Could you consider doing that? Because if, somebody said it's so big and voluminous, well, you can go there and say, all right, these are the 4 things this section covers. Here's the wording. That sounds reasonable, right? Here's a section that says you get the money if we part ways, whatever. And they'll go, oh, okay. And you can very quickly go through all those pages with something like that, rather than going through all the words line by line.
It's actually not that long, Steve. When you download it, it's maybe 8 or maybe 10 pages or so. So why don't we give you that assignment?
I mean, so like I said, I think this was an organic exercise. We had no idea what the response would be, and I will certainly personally take that under consideration. I don't know if we'll reconvene as a group. If we do, which could be a very cool idea, that might be part of version 2.0. I have no issue with it.
There's also email.
So I have a question for everybody in the room. How many people have gone to court with a contractor? Okay, don't you wish you had something like this when you went to court? I'm telling you right now, I would have won in court if I had this. All right, that's the difference. So you know the next contractor I hire, you don't want to sign this contract? No problem. Who's your competition? That's why I got involved in this, because I saw it happen. No, but this contract, not only would I have won, I would have had my house fixed, and I would have had the attorney's fees paid for. And honestly, I'm sitting here. It's funny because these guys didn't go to court. I went to court. I watched this thing unfold, and I watched this disaster happen. Where the judge basically, the first thing the judge said was, "Where's the contract?" And neither one of us. He's a contractor. Wouldn't you think that the contractor would have a contract? How many people deal with contractors that don't have contracts? I bet you that's everyone in the room. So if you have one, at least you have a starting point. As Lee says, at least you have a starting point. You want to start crossing lines out, that's fine. But at least have a starting point, because I had nothing. I have nothing. Now I have to have my entire bathroom redone, which is going to cost me another $20,000. After spending $80,000 on my house, I got to spend another $20,000 to have a bathroom redone because I didn't have a contract.
So do you have an opinion on this subject, Larry?
No.
Oh, okay. All right. Has anybody else? So at the beginning, Lee asked if anybody had any horror stories. Now that you've heard,
Now they're coming out.
now that you've heard the whole story, are there any other horror stories anybody wants to share that could have been resolved had there been a better agreement? Yes.
This is almost non-contractual stuff. And to some extent, I think problems with contractors can be avoided. Now watch, tomorrow I'll have a contractor problem, but can be avoided by, we're lenders. We go in and do the inspection often. And that takes the burden off of the flipper because we can be the person that says, no, this isn't right. The second thing is, and that's the self-serving thing, but the second thing is, I personally learned a great deal from hiring an inspector who went through rehabs and ground-up builds with me, trailing along like a kindergarten student, where the inspector explained to the contractor, this is right, you did it right here, or you did it wrong here. So all of those problems are laid out by somebody with more expertise than the contractor, because he's been, perhaps a codes inspector, somebody like that. And it was a great relief because there was nothing to argue about. The roof was done wrong. Here's why it's wrong. Here's the code. Redo the roof. And we've had situations where they've gotten done that way. So you can almost take some of the contractual issues and bypass them with that kind of thing. The only other thing, and this is hearsay, but I'm going to repeat it anyway. I heard last week, was told by 3 developers in Philly anyway, that the permit can't get pulled by a general contractor unless that contractor has a license, which means that contractor has liability insurance, workers' comp, a business license, and something else, one other. Yeah, I understand that. I know it's Philly. I know that. I'm just saying that in terms of having to check the state site. No. Yeah, no, and I'm not suggesting that either, that they are, but it takes a little bit of the burden off of, there's a little bit of oversight there, so I'm done.
Yeah, so I'm also a lender. I don't do the inspections that Mike and Karin do, but in the early days of my lending business, I got involved in deals where the, let's call it the subcontractors, may or may not have had green cards, all right, and may or may not have had insurance, and certainly weren't skilled. Shame on me. I didn't understand those things at the time. I understand a little more now. But whether you're a lender or an owner, these are really important things. And whether you use this contractor or not, there's a lot of money floating around here. And like Larry said, if there's a clear agreement between parties, then there's a clear agreement between parties. The worst thing that can happen is at the end, it's a he said, she said, and then you don't know, or he said, or she said, she said. I don't get involved in that. But it turns into a mess, and the idea is to avoid that as much as possible. And that's the whole point. So as a lender, I want to be really careful going forward to make sure that that relationship is really good, because it's to everybody's benefit. It's you either pay me now or you pay me later. It's actually you pay me now or you pay me a lot more later. Not me, but I mean, the problem becomes much more expensive later on. What's that?
That's possibly me. I mean, that's part of the reason.
That's right. That is you.
Well, that's part of the reason that this contract made sense is because we're seeing people who either don't have contracts in scenarios where that's not a viable option, or contracts that are like, I mean, I have a contract scrawled on the back of a placemat. And they just don't capture the issues that are protective of any of the parties. So this was a kind of jump-off point to get some of these issues flowing in people's minds. And to Don's point, I mean, hopefully it prevents some of those issues.
So we should probably wrap up if we can. Yep. I don't know what's next. Okay. So this is the piece of paper that you should have all gotten. If you didn't get it, there may still may be some paper back there. If not, you can take your phone out. If you have a QR code reader, take a picture of the screen. You'll be able then to download the agreement. And whether you do it tonight or later on, that's okay too. Okay, any questions?
Hello.
That's better.
I want to give a testimonial for at least 2 people in the room. First of all, I've had several conversations with Lee, and you guys get the idea that I'm really fascinated by the law. So although I haven't used them yet, I've been trying to. Every deal I have falls apart before I get a chance to use them.
I'm that good.
I actually want to say I actually believe at this point he's really good. But I also want to say that Matt has been my insurance agent for 5 years, and frankly, I didn't want to hire Matt because I thought he was too good to be true. Because what's the big problem we have with insurance agents? They don't call us back. This is one guy who actually calls you back, so I highly recommend Matt as well. And of course, the other people in the room that I always know are good are these guys over here. But they don't care that I tell them they're good. And Don, of course, is wonderful too.
Well, I think we should give a great round of applause not only to Lee, but also to our contributors, including Kenny and Bill and Larry and Matt and George, who hasn't said much. Do you want to say anything, George, before?
George, you here?
I think there's so
Three,
much
number
that we get in. I think there's so much that we can get into, and it'll take 5 to 10 hours to get into it. Because this is just a contract. To me, this contract's great, but there's so much that's more important before getting to the contract. So for guys like us that have done hundreds of renovations and went through the school of hard knocks, you know, it's easy for us. For people that are starting their first or second renovation, there's a lot we can get into. Interviewing the contractor, you know, knowing who does good quality work, you know, walking through their projects. I mean, there's just so much.
Yeah. Yeah. How many flips have you done, George?
I've done 700 flips.
Yeah. So
And
you can spell flip, right?
yeah, we did 50 last year, probably 7 this year. But I've been doing it for, 30 years.
Great. So round of applause to our contributors and a great round of applause to Lee. Thank you very much.